Hello, good morning. Welcome to this webinar on TUPE 2024, your first webinar of 2024. Gosh, it's a frightening sound, but it's 2024. What better start could there be to a Thursday morning than talking about TUPE? You don't all have to shout in acclamation or agreement with that. Just to mention a few bits of housekeeping, I'm very pleased that talking about TUPE today, I have Joe Bryan with me. We did a recent webinar recording and we were plagued with pings of people accessing the system. I think we've ended that as a problem, so hopefully you shouldn't have any difficulty. It does mean you can come and go as you want. There will be a recording of today's webinar, and that will be made available to all of you, and it'll also be at some point locked up on the Chamber's website. We're going to deal with a number of topics today. Joe is going to be talking about some recent TUPE case law on liabilities that transfer and also on data that transfer and the issue of cross-border transfers. I'm going to have a look at TUPE after the retained EU Law Revocation Reform Act and the impact on TUPE from the 1st of January of this year, and also the recent amendments which were heralded in the summer to TUPE in the Employment Rights Amendment Revocation Transition Provision Regulations 2023 that fit into that context of revocation and reform. We're then are going to go into, once we've concluded that, if you've had enough, feel free to leave. If you haven't, we were going to do a TUPE clinic where we invited some questions. We've had a few questions. However, if you feel that you want to ask a question, there's a chat box. Please put your question in the chat box and we'll endeavour in the TUPE clinic to address it if we can, or point you in the direction of a better brain to answer it. And one point of warning, obviously it will be recorded. Put your question in the chat box. Try and avoid anything too client specific. Obviously generic question problems great. I did once have that in a case where I'd seen a seminar where I was doing a seminar about TUPE and someone came up to me in the break and said, I've got a really interesting question. What would happen if you did X, Y, and Z? And I said, oh, that's really interesting. Would you mind if we frame that as a question in the next bit? Because we're coming up to that topic. And they said, well, I would really, because the person I'm going to be doing it to is actually sitting in the seminar about 3 desks over and in the law firm that's on the other side. So that was a reasonable request. So put it in the chat box when we get there. As I say, Joe is going to kick us off with issues relating to recent TUPE case law. Joe.
Thank you, David, and morning, everyone. Our first topic, as David says, is the liabilities that transfer. And we'll be looking at the most recent authoritative judicial decision on the issue, which is Ponticelli Limited and Gallagher. And that was a case which arose in the context of a share incentive plan. Before we get into the detail, though, I think it's worth reminding ourselves of the key provisions in play. I've put them up on the slide there. Regulation 4 of TUPE deals with the effect of a relevant transfer on contracts of employment. And paragraph 1 of that regulation is the touchstone provision for the novation of contracts on a TUPE transfer. And of course, it provides that the transfer does not operate to terminate the contracts of employment of an employee assigned to the organised grouping of resources, and that the contract continues as if it had been originally made with the transferee. For our purposes of Ponticelli Limited and Gallagher, the relevant provision is particularly paragraph 2, which worth reciting in full, provides that without prejudice to paragraph 1, which we've just seen, but subject to paragraph 6 and regulations 8, 15 and 9, on completion of a relevant transfer A, all the transferor's rights, powers, duties and liabilities under or in connection with any such contract, that's the bit to highlight proverbially, under or in connection with any such contract, shall be transferred by virtue of this regulation to the transferee. Now, that, of course, has its origins in the European directive, the Acquired Rights Directive, which was most recently reenacted in 2001. Now, David's going to discuss later, as he says, the impact of the retained EU Law Act, but for present purposes, it suffices to highlight 2 points about the directive. First, in the usual way, the preamble to the directive sets out the premises on which it's built, and they include, in particular, and I quote, that it is necessary to provide for the protection of employees in the event of a change of employer, in particular, highlighters out again, to ensure that their rights are safeguarded. That's in the preamble. And the second point to note about the directive is then that objective is reflected in Article 3.1, which provides that the rights and obligations of the transferor arising from a contract of employment or from an employment relationship existing on the date of the transfer shall, by reason of such transfer, be transferred to the transferee. All that is a roundabout way of saying that the directive supposes that the contract of employment on the one hand and the employment relationship on the other are at least conceptually distinct matters. And there is subsequent case law, which we don't have time to go into now, which confirms that they are indeed two separate contexts. So with that in mind, turning to Ponticelli Limited and Gallagher, which was an opinion of the inner house of the Court of Session. This tackles head-on the question of whether a liability that is not contained in the contract itself transfers. So a liability that's not within the four corners of the employment contract, does it transfer? And the particular facts of this case were that Mr. Gallagher had participated in a share incentive plan operated by the transferor employer. His entitlement to participate in that SIP was detailed in an agreement which was separate from his contract of employment, and there was in fact no reference at all to it in his employment contract, and it was a purely voluntary scheme that he was entitled to participate in if he so chose. Now, both the First Instance Tribunal and the EAT had held that following the transfer, Mr. Gallagher was entitled to participate in a SIP of substantial equivalence or comparable value to the one that had been operated by the transferor employer. When the case reached the Court of Session, the issues had narrowed, and the principal issue for the Court of Session was whether his entitlements under the SIP were, and we're coming back to the wording of the regulation here, were rights under or in connection with his contract of employment, such that they or broadly equivalent rights transferred to his new employer. In order to resolve that question, the court engaged with an argument by the employers, by the transferee, that the decision of the Court of Appeal, the previous decision of the Court of Appeal in Chapman and CPS Computer Group, was, and this was the submission made, authority for the proposition that benefits available to employees under contractual arrangements that were wholly distinct from and collateral to the contract of employment do not transfer under Regulation 4.2a. Those are the key battleground terms, if you like, distinct and collateral liabilities. So what was Chapman all about? Chapman was a case which, at least at first blush, was not dissimilar on its facts to Mr. Gallagher's case. The transferring employees in Chapman had been members of a share option scheme. However, the particular terms of the scheme in Chapman had entitled the employees to exercise their share option, within a certain period, in the event that the employment was terminated by reason of redundancy. And the question for the Court of Appeal in Chapman was whether, notwithstanding the TUPE transfer, the employee's employment with the transferor had terminated by reason of redundancy. So in effect, the Court of Appeal was grappling with the question was could there be both a TUPE transfer and a termination by reason of redundancy for the purposes of the share option scheme in place in Chapman. Now, as the EAT had observed in Ponticelli, Chapman has been the subject of some criticism, but I'll just park for now, for the moment, how the Court of Session resolved that particular point about Chapman, and I'll return to that in a moment. But that's the key summary of Chapman. The other important case to note for present purposes is the well-known decision in Mighty Management Services Limited and French. That had considered the situation where it was impossible, in any practical sense, for the transferor to provide the benefits to which the transferring employees had been entitled under a profit sharing scheme. Mighty didn't create the principle of schemes of substantial equivalence, but it is perhaps the clearest judicial authority for the principle that the liability that transfers in such a case is a liability to provide a scheme of substantial equivalence being the touchstone. So those being the key preceding authorities, how did the Court of Session decide the case in Ponticelli? Well, it dismissed the company's appeal. On the Chapman point, the court didn't in fact find it necessary to decide whether Chapman had been wrongly decided or whether the criticism in academic circles of Chapman was justified, because in fact the Court of Session decided that Chapman was capable of being distinguished on its facts. According to the Court of Session, we therefore have an authoritative judicial interpretation of Chapman. What Chapman is really about is really just construing a particular clause in the particular share option contract that arose in that case. So in a sense, Chapman was confined to its facts and didn't go so far as to consider the broader question of whether rights under that contract arose, to use the words of the regulation, in connection with the contract of employment. So that analysis enabled the Court of Session, in effect, to put aside Chapman and to dispose of the submissions in relation to it in that way, and then to return to the facts of Mr. Gallagher's case. And on those facts, it upheld the analysis of the First Instance Tribunal and the EAT. In the words of the Court of Session, it was enough that, quote, the rights and obligations under the scheme, that's the SIP in which Mr. Gallagher was participating, formed an integral part of his overall financial package. That was the key reasoning on the facts of Mr. Gallagher's case. And what gave rise to that decision? Well, his contributions to the SIP were made by monthly deduction from his salary, so there was a direct link with his contractual benefits under the employment contract. There was also a process for his employer to contribute matching shares in certain circumstances, and there was also a link between part of the plan, part of the share incentive plan, and the employer's separate bonus scheme. So it's clear to see that there were a number of connections with the contract of employment itself and the benefits arising under that contract, even if the SIP was separately a benefit accruing under a different contract. To put the matter beyond any doubt, the Court of Session went further and held that its decision would have been the same whether or not it had been applying the words and provisions under TUPE or under the directive. So the decision would have been the same either way. I've picked out what I think are 2 points of particular interest for practitioners rising from the Gallagher case. Number one The breadth of the transferring liabilities is reaffirmed, and well known are the authorities that make clear that it is a broad interpretation of the liabilities transferred under TUPE, but that is only reaffirmed by the decision in Mr. Gallagher's case. In a fairly telling phrase, the Court of Session made clear that the liabilities do not need to be, quote, a product of the contract of employment, a product of the contract of employment. The query whether that puts an unnecessary gloss on the wording of TUPE, arising under or in connection with a contract of employment. The phrase being a product of the contract doesn't appear anywhere in the regulations or in the directive. Arguably, it's an unnecessary gloss, but I've no doubt that formulation of the test will be relied on in submissions made in cases similar to this in due course. It doesn't need to be a product of the contract of employment to transfer. And the second point of interest is really coming back full circle to the preamble to the directive itself. And the Court of Session in Ponticelli expressly made this point. It came back to the fundamental purpose of the transferring liabilities, which is the protection of employment rights. The Court of Session was at pains to point out that if it had reached any other conclusion on the facts of this case, it might have opened the door to transferees seeking to subvert the purpose of the regulations and transferors by bestowing benefits outside of the four corners of the contract. Now, I've suggested, perhaps somewhat boldly, that firmly closes the door on any attempts to subvert the purposes of the Acquired Rights Directive. The door may not be completely closed, locked and bolted, but certainly at the very least, any employers endeavouring to get around the case law in this respect will now be finding heavy authority pushing firmly against them if they're endeavouring to open that particular door. Ponticelli is a pretty resounding decision on the point. Let's turn to the potentially knotty issues of identifying the date of a transfer and TUPE issues in the context of cross-border transfers, both of which happily arose in the case of Rajput and Commerzbank very recently, a decision of the EAT. Now, those issues arose on the sale by Commerzbank of part of its business, the Equity Markets and Commodities Division, the EMC division, in which the claimant, Ms. Rajput, worked. She was a senior compliance officer. Now, the intricacies of the sale were described by the tribunal as complex and multinational. The sale took place by a lengthy and intricate series of transactions, each known as a batch or a sub-batch. When you read the EAT decision, there's references to batches of business, batches of employees and clients transferring at different times and places. But fundamentally, the EMC was the business, which was the economic entity which retained its identity, whose business was carried on by the bank from the transferee bank from the transfer date. And there was no dispute that Ms. Rajput was assigned to that EMC business. Maybe a relief to know that we don't need to grapple with every intricacy of the particular corporate deal and the way it was structured. For present purposes, it suffices to note the following by way of background. 3 points, really. Number one, there were three main areas of the business of the bank's EMC division, and they were spread over several countries. One of those, I'll note because we'll come back to it, was the so-called flow trading business, known as Flow in the judgment. We'll come back to that. That was mainly based in Germany, that part of the business, though it did have a small London presence. The second point to note on the facts is that the EMC business that was transferred comprised over more than 300 employees. And as I've said, it was affected by this series of transactions over a long period, and that period stretched from February 2019 up until about April or May 2020. And in short, each time a batch of the business was transferred, specific clients, specific employees were transferred over to the transferee bank, which thereby gradually took over the active management of the entire EMC business. And the third point to note is that it was agreed as a fact that by October 2019, about 95% of the entire sale had been completed, albeit other aspects of the sale remained to be completed thereafter. Now, why was this of relevance? Well, Commerzbank, the transferor, purported to dismiss Ms. Rajput in March 2020, note several months following October 2019, at which point 95% of the sale had been completed. So if the date of the TUPE transfer had been before March 2020, and both of the banks were saying that it had been in October 2019, several months before the alleged dismissal, then there was a question mark as to whether that had been an effective dismissal at all. So that was the practical impact of this part of the decision. Ms. Rajput's case was that the date of the transfer was when the last in the series of transactions was completed. And that appeared to be a date which was later than the date on which she was purportedly dismissed. So that appeared to be a date in April or May 2020. So for our purposes, and I've put this up on the slide here, there are three crucial questions. First, where a transfer is affected by a series of transactions, is the date of the transfer for TUPE purposes the date of the last transaction in the series? That's question one. Question two, what, if anything, is the relevance of the date on which the, quote, essential nature of the business activity is first carried on by the transferee? And third, in the case of a cross-border transfer, should the focus be on the UK-based part of the transfer business or on something else? So those are the three issues which we'll consider in turn. The first of those, then, the date of the transfer. Before we turn to the reasoning of the EAT in this case, helpful, I think, to recall the leading European authority on the point, which is the Court of Justice decision in Celtec Limited and Astley, citation given there on the slide, which had held that the date of a transfer within the meaning of the directive means, and I'll quote it, the date on which responsibility as employer for carrying on the business of the unit transferred moves from the transferor to the transferee. And the second point to note about Celtec is that it held that the date of the transfer will be a, quote, particular point in time. And that latter point, at the particular point in time, had been taken up by the EAT in a previous case, Metropolitan Resources Limited and Churchill Dulwich Limited, where it was held, albeit in the context of a service provision change as opposed to a transfer, that what Celtec requires in this context is for the tribunal to find a single date on which any type of TUPE transfer occurred on the facts before them, but it doesn't require that all of the steps which constitute the transfer take place on the same day, which seemingly obvious point, but worth reiterating. So far, so clear on the authorities. The tribunal is in the business of ascertaining a single point in time, which is to be treated as the date of the transfer, even where it's affected by a series of transfers, perhaps especially in such a case. Now, should that date, as Ms. Rajput argued, simply be the last in the date of the series, because that's when, she argued, the transferee took on full and final responsibility for the, in this case, for the EMC business. Well, the tribunal, the EAT, rejected that, and as I've noted on the slide there, rejected the idea that there was a rule or presumption that the transfer would be a transfer effected by a series of transactions occurs at the end of the series, and made the fair point that the final transaction might well just be a minor detail, putting the last piece of the jigsaw in place, to use the words of the EAT. Everything will depend on the facts. But what's clear is that the claimant's argument, Ms. Rajput's argument, that it had to be when full and final responsibility transferred, was rejected. That's not the test, and CELTEC does not imply any such requirement. What about then this second question, the terminology of essential nature? Well, the terminology of the essential nature came from the EAT's decision that I've mentioned already in Metropolitan Resources Limited and Churchill Dulwich. That appeared to require the tribunal to assess the date, arguably contrary to the CELTEC test, to assess the date at which the essential nature of the business activity is carried on by the transferee. Now, is there a tension there between CELTEC and the domestic authorities? Well, the way the EAT and Rajput dealt with this was that argument largely stood and fell with the rejection of the full and final responsibility submission. But in the end, whilst not entirely, I think it's fair to say, not entirely endorsing the Metropolitan Resources formulation of the essential nature test, the EAT held that there was no fundamental tension there between the domestic and the European case law. So ultimately, there's no tension, and whether the words essential nature or responsibility are used, it makes no difference. Really, though, the tribunal should be deferring to the purer test from the CELTEC decision. Thirdly and finally, then, cross-border transfers and the difficulties that may arise there. Should the focus, let's remind ourselves of the question, should the focus be on the UK-based part of the business? Putting that another way, was the tribunal wrong in this case to disregard the non-UK based parts of the business? Now, how did this arise? Ms. Rajput was assigned to the EMC business that was situated in the UK, but part of it, the flow element that I referred to earlier, was mainly based in Germany, and the transfer of that element, the Germany-based flow aspect of the business, didn't complete until May 2020, so following the date on which she was purportedly dismissed. The tribunal, however, had excluded that aspect from its consideration because it was non-UK based, and that was the error. The case had to be remitted to the ET for further consideration. So I'll just set out in brief what the EAT's reasoning was in reaching that conclusion. The EAT set out essentially a series of propositions, and whilst those are of course tailored to the facts of the Rajput case, it seems to me that they can be replicated in other similar cases of this nature. So the propositions were these. First, there was no doubt that the part of the business transferred included the flow business. That is to say, there was no doubt that the business unit included aspects that were based in non-UK locations. Second, it was common ground that the claimant was assigned to the part of the business transferred, that is to say the EMC business. Third, there was no reason why the organised grouping of resources cannot be physically located in several countries at once, and that was the case here, and it may be the case in many such cross-border transfers. Fourth, it was common ground that the economic entity that retained its identity, i.e. the EMC business, was situated in the United Kingdom, notwithstanding the physical locations elsewhere. Fifth, there's nothing in TUPE that means that the involvement of foreign law or legal systems prevents the regulations from applying to a transfer. And finally, there's nothing in TUPE that requires expressly the tribunal to confine its consideration to the part of the unit transferred that's based in this country. So stepping back from all of that, the take-home message, I think, is that the Court of Justice's responsibility test in CELTEC applies to the whole and not just the UK-based part of the transferred business. I think at that point, and certainly with an eye on the time, it's appropriate to turn to the European question, and I'll hand over to David.
Thank you very much, Joe. I'm hoping that you now have a slide on TUPE after the Retained EU Law Revocation and Reform Act. So, transfer of undertakings, protection of employment regulations. We're all friends here. What we can recognise is that when the legislation speaks about the protection of employment, the protection of employees that are involved are in fact employment lawyers. I've always thought that the entire structure of the transfer of undertakings regulations is intended to ensure the employment of employment lawyers across Europe, and indeed I'm personally grateful for it. It was therefore perhaps a matter of immediate concern when post-Brexit it looked as though there was the prospect of TUPE disappearing. That seemed, however, comfortingly to be resolved by the European Union Withdrawal Act 2018 that retained as a snapshot in law at that particular point in time EU law as it stood, and that was at the end of the implementation period on the 31st of December 2020. And therefore we had the regs, but more importantly, we had frozen in time the underlying directive, the 2001 directive, and the case law of the Court of Justice as it stood in relation to TUPE at that particular point in time. We then this year had a flurry of the prospect of the draft Retained EU Law Revocation Act in the summer, contemplating, or rather earlier in the year, contemplating the revocation of everything based upon retained EU law other than specified elements. And it appeared as though at that stage TUPE would disappear from legislation, the regulations being primarily made under the delegated power under the European Communities Act 1972. Apart from some aspects made under legislative other powers, would disappear. A lot of consternation, but also a lot of politics. And then instead we had, on the 29th of June of this year, the passing of the Retained EU Law Revocation and Reform Act that takes a different approach. Now, the purpose of this particular section is really to focus upon TUPE. If you want to see a more detailed analysis of the structure of the Act, you may have already attended or watched. There's a separate webinar. I'm afraid to say you're going to listen to me again, but there is the advantage of listening to Blaston Bredlin, who's much more entertaining than me, on the topic of the Act and the way that it works for the purposes of EU law. But we're really focusing upon TUPE. But to do that, we have to look a bit at how the Act is going to work from the 1st of January. Now, 1st of January, the Act in its primarily structure comes into force. There are some important parts of the Act which have yet to have the enabling regulations to give effect to them passed, although the intention clearly is that it will all come into effect on the 1st of January. And importantly, we can see some changes which frankly are being rushed through in regulations in order to deal with some of the consequences of this legislation. And in those regulations is a specific provision relating to TUPE. So essentially, for these purposes, what does the Act actually do? Well, the first thing that the Act does is that it essentially changes what had been retained EU law to be assimilated UK law. And so what we had in the context of European law becomes part of domestic law. save to the extent that certain things are repealed. And there's a schedule to the Act of specific provisions which had been created to give effect to European requirements, which are revoked. Importantly, TUPE is not one of those. So, 1st of Feb, European Communities Act 1972 was essentially disappeared, but TUPE under the regulations is not revoked. The regulations stand. However, the devil is in the detail. The Act goes on to make a number of important changes in structure, first of which is the abolition of the supremacy of EU law. Obviously, historically, when we'd approached questions about the interrelationship between domestic law and European law, in particular the treaties or the directives, had supremacy. And of course, some of those parts of EU law were of direct effect. Well, direct effect ends on the 1st of January. So if it isn't enacted already into UK domestic legislation, you can't go to an underlying treaty or an underlying directive of the community and say, well, that still applies in the UK after the 1st of January. Anything which is in domestic law that gives effect to EU law has no greater supremacy than any other domestic law. And of course, going forward, it means that if there are changes in domestic law, you don't presume that EU law has to be given effect to or is overriding in some way. The approach that one has is to take the view that actually Parliament must be intending to override or change because it's no longer supreme. There is then Section 4 of the Act, and Section 4 of the Act does something which has caused more difficulty and in truth is the reason why we're seeing some regulations being passed through. You'll have seen them, and I think we're contemplating doing an update to the other seminar to deal with this, changes to arrangements in relation to holiday pay. And the consequence of, and the reason for that is that the Act abolishes general principles of EU law and their application to the UK. And general principles of EU law include the concept of the Marr-Leasing principle, the ability to read in an extremely purposeful way into domestic legislation requirements to give effect to community law. And working time was a very specific example of regulations where passages and material had been read into those regulations very constructively pursuant to the Marr-Leasing principle to give effect to decisions of the Court of Justice and to give effect to the intentions underlying the directive. Now, the abolition of those general principles means that you couldn't do that going forward. Importantly, we'll also come to a consequence for what has happened to the past. Now, I should say that section has yet to have its enabling regulations put in effect, but as I say, I'm expecting that will happen for the 1st of Jan. So going forward, you do not have to look, if there's a dispute about the meaning of TUPE, and there is some ambiguity or uncertainty about the meaning of TUPE, which hasn't already been resolved in domestic case law, from the 1st of Jan, you no longer go back to the directive, you no longer go back to decisions of the Court of Justice and apply an interpretive process to consider whether or not you need to change the wording to give effect to that. Now, of course, it's worth remembering in TUPE that our TUPE is a little bit of an odd construction, because TUPE was always a basic protective structure. It was always open to member states to build or define protective rights. And we, of course, did that in 2006 by introducing the concept of service provision change, because we thought it was important to clarify with greater certainty when a transfer happened. And I don't know about you, but since 2006, I very rarely ever deal with a transfer where the argument is about whether or not it's an old style EU transfer, retention of an economic entity that retains its identity. So often you're just dealing with issues around service provision change. And you'll recollect in the last few years, there are a number of cases, Hunter being an example of cases where interpretation of that part of TUPE regs service provision change, had to have a literal domestic interpretation because it was purely domestic legislation, and other parts of TUPE, which were giving effect to the directive more directly, could be given a more liberal interpretation. Well, going forward, actually, it's purely domestic processes that have to apply. There's a second issue about Section 4, which we'll come on to. Should say that although things disappear at the 1st of January, there is a power for things to be reinstated or reproduced. But as I say, for the purposes of TUPE, we don't need to worry about that. Now, what about case law going forward? Well, this is where obviously there are issues surrounding TUPE, but pause there. Buried in the schedule to the Act is a definition of what has become assimilated law. And the definition of what's become assimilated law appears on its face to exclude any decisions which relied upon those general principles of EU law, like mile leasing. Now, in the other seminar, the view is expressed that that meant that any old case law from the 1st of January that rested on interpreting purposefully, for example, using the mile leasing principle and reading in entire sections into a statute, fell away. Well, that must be the view that government itself is taking, because they have brought, as part, as we'll see, of regulations that deal with the TUPE aspect, all of the changes I mentioned about amendments to working time. And the only reason those amendments are being made to working time is a recognition that case law that gave us a particular interpretation of domestic regulations falls away. Now, from the point of view of TUPE, there isn't much case law that rests upon a mile leasing basis. I mean, fundamentally, we enacted pretty closely the provisions in relation to the wording of the Acquired Rights Directive in its original form, 1977, in the 1981 regulations, and then its recast form in 2001 directive in the 2006 regulations. So actually, the wording, often what we've had to do is not really read material into legislation domestically. We've had to simply look at the wording of our regulations and then look across at decisions of the Court of Justice for help and understanding of meaning. And so an example from that list would be assignment. You'll recollect that once you've identified a transfer, the people that move across are those who are assigned to the organised group of resources or the organised group of people whose principal purpose is carrying out the service. And in terms of assignment, the leading case from a community law principle was Bots and Rotterdamschas. And although, frankly, a case that says virtually nothing other than to say, well, people are assigned to the bit of a business to which they're assigned, we, in reliance upon that case, have built a body of case law in the EAT that developed a domestic analysis of when people are assigned. Now, that doesn't disappear. However, within the Act, there are new powers not vested with the EAT for the Court of Appeal and, in some cases, the High Court, and certainly the Court of Session and the Supreme Court, to depart from earlier decisions which may have been based upon interpretations of community law. And importantly, if there is an argument to say that a different approach should be taken, for example, because there are change of circumstances, or the evolution of the law in a domestic sense in the UK is inconsistent with the old EU principles. I mean, these are very broad concepts. there's a power which we vested in the tribunal and the EAT to state a case up to Court of Appeal or Supreme Court, sort of leapfrog process, in order for them to look at the domestic case law based upon those EU decisions and possibly depart from it. Now, at the moment, I'm not seeing that there is any radical prospect of that changing with the accepted case law. But some of the cases we've got clearly have intermingled in interpreting domestic law using EU principles. I mean, for example, Cheeseman and Brewer contracts, a very old case now, but when you look at the 2006 regulations, and they talk about when there is a transfer, Regulation 31A, the EU model, retention of identity of an economic entity in the hands of the transferee, what does that mean? Well, in every case, one goes back to Cheeseman and Brewer contracts, and Cheeseman and Brewer contracts carried out an analysis of 20 years of EU law decisions to understand when a transfer happened. Now that still stands from the 1st of January, but there is a possibility of people arguing that there are circumstances which should lead the courts to depart from it, and they would be free to do so, certainly at the level of the Court of Appeal or the Supreme Court, to reshape law. And that's important, of course, in some respects, because, we've had a question about this, and Joe's going to answer this, a case like Gewurz, where we scratched our head after ISS Facility Services in Gewurz in 2020, when the EU appeared to open up the prospect that you could have multiple transfers, splitting a contract of employment for an employee being transferred to 2 part-time contracts with 2 transferees. And there was the difficulty of working out how that would apply to service provision change. Well, of course, one might say, going forward, that actually, while now there is no priority to EU law, we have to more closely interpret Parliament's intention in the way that it's structured the regs with those 2 transfers in a way that doesn't give the EU model any priority, but perhaps gives greater priority in interpretation to making the service provision change test work. It's an argument that may be open in circumstances where people try and argue the presence of Gewurz. An example of a case where you just couldn't argue the same principles anymore is using this argument about the absence of the ability to rest upon arguments of a fundamental nature about EU principles. It is a case called Ferguson and Astrea Management. I don't like talking about it much because I lost it, never like that. But you might recollect that it's a case where, slightly to the criticism of all, some bright spark thought of the idea of arguing that the employees in a transfer could change their terms and conditions pre-transfer in order to secure enhanced benefits in the hands of a new employer. Now, interestingly, the argument against that was the literal wording of Section 4 of the regulations, or Regulation 4, which prohibits any variation where the reason or principal reason for the variation is a transfer. And the argument that was being advanced for the employees, unsuccessfully by yours truly, was to say that that was contrary to community law, because the underlying principles in Daddy's Dance Hall said that it was worker protective and employees could rely upon rights which they wanted. The EAT found no, you had to read the regulation as it stood. Now, they decided that in 2020. There will be absolutely no doubt that they would decide that in 2024, because your approach to the regulations would simply be, what is the wording here as a base position, subject to decided cases before and the possibility of departing from them. The other example in that case, which shows how some things will disappear, is that the argument also against the employees was the use of something called the EU abuse principle, a principle in EU law of general principle that you can't rely on EU provisions in order to achieve an intended objective, which was not what the Act was about. And the argument was, well, actually, you're being employees who were also directors of the transferor, using this for abusive purposes to feather your own nest. And the ET found that to be the case, and the EAT found that to be the case, applying the abuse principle. 1st of January, there is no concept of an abuse principle in general EU law applicable domestically in the UK. We're back to the literal wording. So nothing radical immediately happens in terms of TUPE and the established body of case law. However, there is the prospect for thinking back and looking at arguments which have founded cases in the past in TUPE and the interpretation of the regs, and whether or not there's scope for arguing that actually one should consider departing from that case law going forward. Now, one thing that has changed is that when the Act was put forward in May 2023, there was a policy paper that suggested a number of approaches, one of which was the consultation on future work in relation to TUPE. And that proposed only one specific change for TUPE going forward at this particular point in time. Now, of course, it is just worth noting that one fundamental aspect of this is that now we've lost the supremacy of community law from the 1st of January, it's completely open to Parliament to either revoke TUPE entirely with no difficulty at all, or to make radical changes in the protection or structure of TUPE, more radical than presently is proposed, because there is no underlying structure that prohibits it from doing so. So the change that was contemplated in May and followed through in the response process was a change to one small part of TUPE, which was the section that dealt with consultation and information in the context of transfers. You recollect Regulation 13, the obligation where there are affected employees to inform the affected employees of the transfer and various pieces of information in relation to the transfer, and if there are measures, to consult with them with a view to reaching agreement. And in that context, if there were existing worker representatives, trades unions recognised, consultative bodies with a mandate for TUPE, you consulted and informed with them. If not, you had to elect reps. And that always created a problem in circumstances where you had very small groups of people, because you might have a very small group of people. Do you really have to go through the exercise of electing reps for those particular purposes? Well, the micro business exception that came in previously in Regulation 13A excluded from the obligation to elect representatives small businesses, micro businesses of fewer than 10 employees. I should say, importantly, it only excluded that micro businesses if there were not already recognised trades unions or elected reps. But if you had fewer than 10 employees as a micro business and there were no elected representatives, you hadn't invited the election of representatives, and you had a transfer of that small business, you didn't have to go through the election process. You could comply with the obligations by simply performing your duty in relation to each of the 10. Now, there's a catch in that. We'll come back to it. So what's proposed to take effect from the 1st of Jan is to expand the scope of that exclusion. And importantly, it expands the scope of the exclusion in two ways. I should just pause to note, it's always worth remembering this. Sometimes people lose sight of it. When we took at Regulation 13, it doesn't say that the people that are excluded, the people who are affected, who have to be informed and possibly consulted about a transfer, are the people that transfer. It doesn't even say the employees of the transferor. It says any employees of the transferor or transferee who are affected. So they may be people who are not transferring, who might be affected by a transfer. If I work for a company and there is a transfer coming in where there are 30 new people coming in doing my job, and that's likely to lead to reorganization or redundancies, I am being affected by the transfer. And in principle, the transferee should be informing and consulting with me about those measures. Now, often people ignore that, but that is the basic structure that's being applied here. So two caveats under the regs are, firstly, if there is an employer that has fewer than 50 employees, that's a whole employer, this cutout under Regulation 13 for micro businesses is extended to include them. And that's whether you're the transferor or the transferee. So I'm a 49 employee transferor, and I'm transferring the business of my company to a new employer who's got 150 employees. I'm within the scope of the exclusion. They aren't. I, as transferor, can discharge my obligations simply by dealing with the individuals who are affected. I'm their employer. The transferee has to go through elected reps. There's then a second cutout, which is if the number of employees, if fewer than 10 employees are going to be transferred, then both sides are cut out. So I'm 150 employer transferor, and the transferee is 150 employee transferor. They don't cut in that fewer than 50 exception, but actually the transfer is only involving fewer than 10 people. Suddenly we're in this micro position. But there is some catches, as I say, in that the regulations don't completely lose your obligations, even if they apply. And that is a big catch with them, because what they don't do is say that you only have to give information to the workers. Okay, you'll recollect under Regulation 13 that if you invite elections and people don't stand for election, you're discharged from an obligation to consult with representatives. You just have to tell people the basic information about the transfer. The exclusion, even though it's widened, does not change that. It actually says that where the exclusion applies, you discharge your duty by treating each of the affected employees as if they were a representative. Well, that means if there's measures, you've got to consult with a view to reaching agreement with each individual who's affected. But actually, that's more complicated potentially than having an elected rep. You know, you might only you might be an employer who's got 50 people, and therefore you are 49 people, and therefore you're within the exclusion, and you're transferring, and you think, marvelous, I'm in the small exemption now that's been widened out. I don't need to elect reps, but actually I'm having some measures, very broad concept. I'm changing people's pay, I'm changing arrangements about when people are paid, or there's going to be a change in location as part of the transfer. To comply with the regs, you have to not only inform every one of your 15 employees, but those measures, you have to consult with them with a view to reaching agreement. Well, you can't really easily do that because you couldn't have disparate measures across the piece. So the reality is you probably would still think you're better off electing representatives in order that you can discharge the obligation specifically only with an individual. So it's an important change, but one wonders practically, other than quite small transfers, in other words, fewer than 10, that the 50 bit may not be a great help, but it's really only in fewer than 10 employees that actually the engagement really has a significant impact. Of course, for the future, we don't know. Will they make more provisions in relation to changing or amending TUPE in a way that liberalises other aspects of it? The debate's often been about issues relating to ability to make variations or dismissals in a TUPE context. Personally, I think that the present wording of the legislation, which provides for variations only being prohibited if the reason or the principal reason for the variation is the transfer, and the fact that dismissals are only protected if the reason or the principal reason for the dismissal is the transfer, already means that the protection is very narrow in practical terms. But that's a different topic. So 10 o'clock, TUPE clinic. So as I said, fantastic to have all of you here. We've had a few questions. Happy to take any more questions. The chat box is open. If you want to stay, please do. We'll deal with the questions now. When we finish those questions, we'll stop. The moment I suspect we might be probably subject to a stinker of another question, probably about another 10 or 15 minutes. The whole thing is being recorded. Have an eye, therefore, on your question and what may or may not be articulated in it. I think the first question that we had was a question that Joe was going to deal with, which was about Gewurz.
In fact, before I come to David's question about Gewurz, I'm going to deal, while it's fresh in our mind, with the question that's come in through the chat from Hannah. Thank you, Hannah, which I'll just read out very quickly. This is a question about Ponticelli. Gallagher was entitled to participate in a scheme of substantial equivalence because he was in fact participating, therefore had rights under a collateral contract. Non-participating employee would not have such a right. Is that correct? And question 2, the courts contemplated that the SIP was terminable in accordance with its terms, didn't consider that, as in fact no effort was made to do so. Do you have a sense of how a transferee might go about trying to terminate the SIP or use a route to avoid putting equivalent scheme? But Hannah, I think the question goes to the heart of the matter, really these cases always turn on the precise the particular terms of the contract or scheme in question, and that really then draws out the ratio of the Ponticelli case. The scheme in that case was purely voluntary. It seems unlikely then that it would have been something that would have transferred in the absence of actual participation, as indeed was the case in Mr. Gallagher's case. So I think the answer to your first question is probably yes. The wider question is question 2, about how you, as a transferee, might go about avoiding the consequences of the SIP transferring. It seems to me that the straightforward response to that is that the scheme would be terminable in accordance with its terms. And I think that flows from point 1, it flows from Regulation 42A itself, which provides, and we haven't touched on this in any great detail up until now because we've been focusing on liabilities, but 42A also refers to the rights of the transferor transferring. And of course, one of those rights in this hypothesis would be the right to terminate the scheme if there is such a provision within the scheme itself. So that right would transfer to the transferee, and it would simply be a case of executing the termination in accordance with what's contractually agreed. And I think that analysis is also consistent with the general principle that the purpose of the protections for employees under the Acquired Rights Directive is not to is simply that, is to protect the rights. It is not to afford workers the opportunity to gain rights which they would otherwise would not have. That's reflected in cases like computer share. So it seems to me that the answer is that if there is a clause in the plan which enables a contractual termination, then if it's executed in accordance with those terms, then that would be the transferee's route. The second question that David referred to about Govets was the consultation, the recent government consultation, a missed opportunity to address concerns about the Court of Justice decision in Govets. Well, briefly remind ourselves, David's already referred to it, the ratio of that case was that in the case of a transfer to multiple transferees, an employee is effectively transferred pro rata to each transferee. It might be said, if we take a purely hypothetical circumstance, the Rajput case might have been different, might have been in Govets territory, because Rajput herself performed work across different areas of the business. Now, if on completely hypothetical facts, if the bank had transferred parts of the unit to different transferees, then an employee such as Miss Rajput, who had been working across those several parts, might have then transferred in proportion pro rata to each of the different transferees. That's entirely hypothetical, but just by way of illustrating the principle. But of course, what that demonstrates is that it is a notoriously difficult decision to implement in the real world. There is then a temptation to say that it should be confined to its particular facts, but sadly for us as advisors, it's not infrequently the case that these transfers to multiple transferees arise in practice. And indeed, Govets has now been applied in a domestic context. Unfortunately, the government's response to the consultation, whilst it did expressly refer to Govets, expressed a reluctance to do anything about it, and merely noted that it was aware of the Govets case and its implications, and it's continuing to monitor. Not for me to say whether that's a missed opportunity, but it does seem that, given the pre-Govets general reluctance on the part of the domestic authorities to sanction such an approach, on the basis that the common law generally sets its face against one servant having two masters, it might have been thought that this was an opportunity to address it.
I'll deal with Katie's question first. And Katie's question was, please may I ask about the enforcement of post-termination restrictions in circumstances where employees have objected to the transfer. Are you aware of any proposed changes? Thank you. So, number one, I'm not aware of any proposed changes. The position in relation to objection and post-termination restrictions has popped up in a few cases. I was in a case which sadly wasn't reported, which grappled a little bit with this, in the sense that the effect of an objection, and typically why people don't do it, is that unless you can establish that you're within the scope of the protection for substantial change in working conditions to your material detriment, where you can claim it's a dismissal, the essential effect of an objection is to terminate your employment at the point of the transfer without notice or redundancy play. Your employment simply operates. Now, of course, there are some circumstances where people might consciously want to do that because they want to leave and take up employment with a new employer. Slightly odd on the facts because the objection came after the transfer, and it's odd in that respect. An interesting example of that happening is a case called New ISG and Vernon, 2008, IRLR page 115. But does it do you any good? Well, there is one question, it came up in the case I was in, which is, well, if it's not a dismissal, what happens about the covenants? Obviously, you need to look at the contract to begin with, because the contract might define when the covenants come into effect in a very narrow or prescriptive way that doesn't capture the termination of a contract by effect of law. That's slightly unusual. Normally, people deal with termination definitions in a very generic way. In the case I was in, it was actually about whether or not someone was entitled to a bonus that was going to be paid if they hadn't given notice of termination. And the employer tried to say, well, you've objected, that's notice of termination. And Mr. Justice Underhill at first instance found no, an objection is not giving notice. It's just simply exercising a statutory right. So that's why I say you need to be careful about what the contract says. Second and bigger problem is that if there's been a transfer, the transferee is taking the business, but not the employees who were the subject of the covenants. And of course, that may mean that one's buying something which is vulnerable. Now, there may be a solution to that, and that may involve taking an assignment of the rights of enforcement. That was something that was looked at in UISG. Big problem, though, if you haven't built in the right, if you're buying something in a TUPE situation, you haven't built in the right to compel an assignment. And I always say that to people when they're buying businesses which are people heavy and reliant upon people transferring. Be cautious about objection. There's no obligation on anybody to say anything about objection till really late in the process. They can exercise the right to object very late, and indeed in USJ, in rather odd circumstances, they exercised the right after the transfer, and it was found to go back in time. But if people exercise the right to object, and they don't enter into your employment at all, and you've paid full value for a business that involved those skill sets, it's a problem. So it's worth ensuring that you have mechanisms that deal with adjustment of price and the capacity to compel assignments of the right to enforce covenants if people, contrary to the expectations in relation to the transaction, might object and not transfer. So hopefully that answers your question, Katie. The question that we then had pinged in by Hannah Martin was this. I'd be interested in the speaker's view on where the law stands post Dewhurst in terms of the application of TUPE LIMB workers and how that might evolve. What might be caught under TUPE, and what would that mean for workers with typical arrangements, for example, agency workers? So what we're looking at there is the scope of TUPE. When we look at the regs, it talks about employees. But when you go to Regulation 2, you find that Regulation 2 defines employees in a slightly curious way. It says any individual who works for another person, whether under contract of service or apprenticeship or otherwise, but does not include anyone who provides services under a contract of services. Now, the phrase or otherwise, we know what a contract of service is. Typically, we regard a contract for services as being the opposite. But there's this phrase, or otherwise. And in Dewhurst, a first instance ET decision, Dewhurst and Revised Catch Limited, which traded as e-courier, it was a case about couriers, and also in a case called McCririck and Channel 4 Television. You'll remember that he was that rather colourful tipster who appeared on the racing. Those two first instance decisions concluded that Regulation 2, in that broad definition of employee, was intended not only to catch traditional TUPE employees in the traditional contract of service model, but also LIMB workers. In other words, the whole Uber litigation concept of those who are not in a contract of employment, but are within the wider protected scope of LIMB of the Employment Rights Act. In other words, those who are engaged to work providing personal services. Now, those cases have never been resolved at an appellate level in the AT. And the argument against it is to say, well, if Parliament had intended the legislation to cover LIMB workers, why didn't it say it? Why did it not in Regulation 2? recast as recently as 2006 in the form of the new regulations, against a context where the definition of Limb B worker had been there for many years. Why did it not include it? That's the argument for saying that or otherwise can't be stretched to include wider workers. As it stands, the argument is ambiguously left. The change of the 1st of Jan doesn't really change the ambiguity, because the way that the underlying directive was framed, it left it to member states to apply TUPE protection to those employees as it chose to define the scope of protection at domestic law. So there was no use of the phrase worker in the underlying directive. You never had to interpret the regs to give effect to the directive on that. It's always taken to mean what it means on its literal wording. So the strict answer to your case is, where the law stands is there is a clear argument to say that TUPE embraces Limb B workers, not just employees, but that has yet to be fully resolved. You then mention it's actually a slightly different question, which you say, what would this mean for workers with atypical arrangements, like agency workers? Well, with their employer, the agency, we're back to, is it a contract of employment or Limb B? The slightly more confusing position is where they're provided to work for the transferor. In other words, they're embedded in the organised group of workers. And what happens is a TUPE transfer of the organised group of workers, but there are agency workers. Can they transfer? Well, that again is a vexing question. The simple answer is to say, well, TUPE only applies where you're employed by the transferor. And the transferor is not the employer of the agency workers. All they've got is a relationship with the external agency work provider. But that's quite a simplistic answer to a more vexing question, because you're looking at a situation where they might be agency workers who've been embedded and structured within that organisation for years. And certainly in the Albron catering case, the case about the Heineken brewery, the Court of Justice, in the context of holding companies and service companies, said that the tribunal could look through a structure, ignoring the realities of who the ignoring the technicalities of who the literal legal employer was, and look at the reality to apply TUPE. That's rather difficult with an agency worker. I have previously wondered if there was an argument to say that you could look at the agency relationship and say that there were two transactions going on. When the transferor transferred its business, it stopped using the services of the external agency. And that was a service provision change, because it ended the use of the services of the agency provider. And then there was instantaneously, in legal terms, a TUPE transfer where it had notionally taken back all the activities in-house and then sent them on to the transferee. Now, the problem with that is that could service provision ever change? Because there was no intention ever to carry on the services that it had used agency workers to do. So you might be forced to try and run an EU argument to say it's all about retention of identity. If the whole business is still being carried on in the hands of the transferee, all the agency workers, you should read through the fact and make their agency a transferor, even though it had no contractual relationship at all with the transferee, which according to the regs, in principle under EU law, will be possible. How easy it is to do that post the 1st of January, because you're trying to stretch the meaning of that phrase, employees of the transferor, to embrace someone who's got no relationship at all with the transferee, is more challenging. So I'm afraid that's a long and complex answer, which really sums up with the position is actually there's lots of the capacity for issue and dispute around that yet to be resolved. Joe. Have you had a chance to have a think about Lee's question?
Yeah, so Lee, thanks for your question. Do you have a rule of thumb for when you treat something as one, not fundamentally the same activity as no TUPE, versus two, fundamentally the same TUPE, but transferee simply intends to do it in a slightly different way with fewer people? I think the short answer is I wish I had a rule of thumb. The case law, which I've have to confess I've not recently gone into, does make clear, though, that it is a question of fact on each case. One of the early cases, which I referred to in the talk earlier for a different principle, the Churchill-Dulwich case and Metropolitan Resources, does address this point, makes clear that it's a question of fact, depending on the particular circumstances of each case. It gives the example, the illustration of where simply, for instance, changing the location in which a service might be provided is unlikely on its own to amount to defeat an argument that there was a service provision change. So that's one illustration of when it might occur. Generally, the authorities tend to set their face against anything other than minor changes in the provision of the activity as defeating the operation of TUPE. What that means, though, is it is ultimately dependent on the facts. There is some, I'll leave others to judge how helpful it is, but there is some judicial dicta to suggest that when we are analysing these kinds of questions, we should neither be too general in our analysis nor too pedantic in our analysis. How that's how helpful that is, I don't know. But what is clear, incidentally, is if there is a deliberate attempt to engineer a situation to avoid the consequences of TUPE, then the courts are certainly going to deprecate that kind of conduct on the part of a transferee. So I don't think there is any easy rule of thumb. I think from those early cases, including Dulwich and Metropolitan Resources, it's clear that it's a question of fact. I don't actually think the thicket of case law that's followed that fundamentally changes that position. It is always going to depend on the particular facts of the case, but minor incidental alterations, change in location, perhaps change in minor changes in structure or particular personnel or operating hours, are not likely to be the kind of things that would amount to a fundamental change. But I think beyond that, it's difficult to draw out any particular hard and fast principle.
Yeah, can I chip into that? I think that's right, and I agree with that. That it's worth. I've just pulled out a couple of unreported cases that sort of interesting just to pick up on that, and they show the problem about this. I mean, the Churchill-Dulwich case led to one of the few amendments that were made to the 2006. Sorry, in 2014 to the service provision change definition, because they added in a specific requirement that the service had to be fundamentally or essentially the same. And as Joe says, that's a question of fact. But when one looks at some of the cases, one can be sort of, very troubled about where the lines are about that. I always find a great case example is this OCS Group and Jones I put in the chat. That involved the canteen at the BMW car plant in Oxford, and there had been a canteen that sold, music to my ears, the full range of proper canteen, treacle tart, cooked meal, your proper lunch, and the company decided to end the contract for one provider and get a new catering provider in. In fact, the new catering provider took on some of the staff, but they completely changed the way the canteen worked. And instead of doing hot meals and proper puddings, they did sandwiches, a sort of buffet type cold food service. And an employee was sacked And to claim that they got sufficient service, they needed to say it was a TUPE transfer. And so it became, was it a service provision change? And the whole case turned on fundamentally or essentially the same. And the tribunal found that the new form of buffet was not fundamentally or essentially the same service as the previous one. Now, I struggle with that. The union's case, and frankly, I see force in it, was to say, well, surely the service was about providing food to the workforce. You're doing the same service, you're just changing the nature of the provision of the food. But the tribunal found no, the two catering services were not fundamentally or essentially the same, no service provision change. Another interesting example, we probably don't have time to go into it, although one for Home Turf, on reported Ward Hadaway solicitors and Love and others, a TUPE transfer argument between law firms, where one law firm had the contract for carrying out the prosecution of, if I remember properly, it was, I think it was nurses in their disciplinary process. And there was a new structure put in place to deal with the investigation and prosecution of cases. And that led to a set of circumstances where the first law firm tried to say that particular employees who they didn't want to make redundant had to transfer to the other law firm. And then the question became, was the service fundamentally or essentially the same? Now, the only caveat to note is, I think, remember that we often focus on the service, but actually when it says fundamentally or essentially the same, the literal wording of the section is the activities. And there's some case law, in particular the EAT decision in Trek, to say, and also a case called Arch Initiatives, to say you've got to break the service down to the activities, and then you have to ask, is there someone you need to frame in circumstances? Sorry, is there a need to disconstruct the service and identify whether there's a particular activity and there's an organised group of people about that activity? So, for example, if in the BMW car works, one person had been responsible for sandwich making and running the sandwich bit, so they had all the cooked food, but they also had a sandwich section, you could say that that activity, rather than the service, did remain fundamentally or essentially the same. But I absolutely agree with Joe that this is a question of fact that can often bed you into quite distinct arguments. It's a question, I think it's a question for you, Joe, about change of location. To what extent do you think a significant change of location, e.g. offshoring, whether the service remains substantially the same? We've sort of been covering that particular ground.
Yeah, I think it follows from what we were discussing earlier. Perhaps the answer is in the question itself. If it is a significant change of location, then that is more likely to be a matter which amounts to a fundamental change, though I suspect that the courts would treat with quite a significant degree of scrutiny to what extent actually the activity itself is changing, as David was alluding to, because one can imagine a situation in which an activity is offshored, perhaps to a very large geographical extent, but ultimately the activity remains in itself fundamentally the same. And again, all turns on its own facts. In a world in which, a corporate world in which offshoring is commonplace, I suspect that the courts and the tribunals would treat that sort of question with a high degree of scrutiny before concluding that it was fundamentally different.
Thank you very much for coming. It's an absolute pleasure to see you all. Have a really successful day. And is it too soon to say compliments of the season? I hope when you get there, you have a great break.